Welcome to Trial by Podcast. I'm Meaghan.
I'm Mariana.
And I'm Fadi.
Today we're diving into 3 trademark battles worth remembering if you ever plan on adopting your own trademark. So first, we'll be looking at some corporate IP beef over burgers between McDonald's and Hungry Jack's. Then we'll look at the trademark face-off between 2 Kylies, being Kylie Jenner and Kylie Minogue. And finally, we'll jump into the Perry paradox, where Katy Perry with a Y and Katy Perry with an IE try to make their IP claim over their stage and birth names. So this is just more than legal drama. These cases serve as a cautionary tale that show exactly why your IP strategy matters. Whether you're a global icon, fast food giant, or a small business dreaming big. So first, we're going to start with Fadi. Tell us a little bit about the IP beef over burgers.
In early 2020, Hungry Jack's started promoting its burgers with the labels Big Jack and Mega Jack. McDonald's decided that this was too close or an infringement of their trademarks of Big Mac and Mega Mac. Resultantly, they took legal action against Hungry Jack's, making the argument that the HJ's mark is deceptively similar to the McDonald's mark, and that as a result, McDonald's said that consumers would be misled or deceived and would confuse the 2 products, even going so far as believing they're from the same source. Hungry Jack's went on to say that no, consumers will actually know that they're different, and that consumers actually rely on visual cues as opposed to phonetic cues, so like the names of products, in making their decision making. Hungry Jack's also made the argument that the Big Jack and Mega Jack trademarks and the burgers themselves would be associated with the other trademarks from Hungry Jack's. For example, the wrapping, the actual physical location, the online store. And McDonald's actually addressed this. McDonald's went on to address this submission by Hungry Jack's by saying actually existing court authority says that regard isn't to be had to any of the anything else other than the trademark. So the judge ended up deciding that the Big Jack and Mega Jack trademarks were not deceptively similar, and that there was no prospect of consumers being misled or deceived by them. The first thing the judge did was refer to the word big in both trademarks, and he said, well, big is actually a descriptive term, and that the common consumer would know what big refers to. It refers to something that's large or an excessive quantity, or it could be something that's a laudatory term. And what he meant by that was if you receive a particular product which is big, right, you might assume that it's greater than something else. Consumers will not be deceived by the word big in both trademarks, even with reference to the fact that they're both beef products and they're both beef hamburgers. He actually goes on to list some examples of other burgers that use the word big. For example, the Big Carl, the Big Queenslander, and the Big Boy. And he says, well, if big is the term that is going to cause the deception, and if big is the term that's going to mislead the consumer, well then how do we address all these other burgers? And what about their trademarks? How do we address that?
And would it be fair even to, take away that option for businesses to market their products as something that's catchy that consumers know is for example, I know I recently went to Five Guys and they have their standard cheeseburger and then they've got like their little cheeseburger. It's just like it's a signifier, right, for these companies to be able to signal to consumers that it's a different size product and what are you actually after? Do you want something that's more substantial? Are you really hungry? Like these are the decisions you need to know. Exactly. When you're actually there. So it wouldn't be fair to go and be like, oh, well, you can't use big anymore to all these companies because of the significance that it has when we're making consumer decisions.
Right. I mean, as was reasoned, it's a descriptive term. And once you start removing descriptive terms from trademarks, you realize that the amount of trademarks that can be applied for and can be afforded, the remit becomes much smaller.
It's limited, yeah.
Right.
So ultimately the decision came down to looking at Jack versus Mac, right?
Right. So he said, the judge reasoned that Mac and Jack, even though there's a rhyme, he argued that there was still enough of a sufficient phonetic difference that the notional consumer would not be confused. And so what he said was that Mac, for example, is a prefix. Well, this is one of the things he referred to. He said Mac is a prefix used in Scottish surnames, whereas Jack is a forename. And he made the argument that he doesn't think that the notional consumer would be confused, even though there is a rhyme. And I think touching on your previous point with the word big, if you start to limit trademarks because they happen to rhyme with other trademarks, even if it's in the same class of goods or services, I think what you notice is that the amount of trademarks that can be applied for, it's basically, it goes against the one of the principles of intellectual property, which is you want to incentivize creation. And so the second you start to limit the ability of IP rights holders to do that, you realize that, okay, well, we're actually limiting the ability for people to be creative.
I think that's a really interesting point. So what did the court ultimately decide?
The court ultimately decided that Big Jack and Mega Jack were not trademarks infringing on the McDonald's trademarks of Big Mac and Mega Mac. The court did, however, decide that Hungry Jack's burgers do not contain 25% more beef than McDonald's burgers.
An important fact to know. What do you guys think about the decision? Do you think Hungry Jack's was infringing on McDonald's? I guess turning a blind eye to the court's decision. On your own take, what do you think?
Well, I found it interesting that the chief marketing officer of Hungry Jack's acknowledged that when they were opting for Big Jack, Mega Jack, they knew there was an element of cheekiness to it and intended to play on that, which you can already see. I think brands do tend, or now because marketing and social media is so big, you can get so much publicity on your products when you're these huge giants. Competing with your competitors is actually a good point of advertising as opposed to something that's going to confuse. And the judge actually talked about the chief marketing officer's comments saying cheeky taunts are often used in that way. And the intent was clearly to compare the two products, not to confuse them, and to leverage that competition. So in that case, how would it be that a consumer would be likely to be confused if you know that there's competing products and that, you know, if you're going to McDonald's, you know that you're getting a Big Mac. You're going to Hungry Jack's, you know that you're not going to get a Big Mac. Yeah. Like you're getting a Big Jack.
Yeah, I agree. I think when I first thought of this, I thought they do kind of sound the same. And I originally thought maybe they are infringing. But I think when you take a moment to actually think through it and think about, okay, Big is just a descriptor, Mac and Jack are different, you'd be buying them at different places. I tend to agree with the court's decision.
Yeah. I mean, ultimately what I think is that what would be the outcome if they were to be found infringing? And then you'd see that, okay, well, now you're limiting people's ability to use certain words in connection with other words.
Yeah.
And at the same time, as you touched on, Mariana, the chief marketing officer said, I know what I'm doing here. I'm trying to induce consumers to think and compare the two, but it's not in a way that's likely to deceive or mislead them.
Yeah.
Right? And that was the main, I think, the main qualifying factor for the judge, which is, okay, you can have that level of competition, and competition's a good thing. We know that in markets, but not to the point where people are saying, okay, well, these burgers must come from the same source, or one company is responsible for both burgers. And I think that wasn't the problem here. So I do agree with the judge's decision.
Yeah, interesting. Well, let's jump into our next IP battle. So we've got two global stars, but there can only be one Queen Kylie. So we've got Aussie pop icon Kylie Minogue, or reality TV star and cosmetic mogul Kylie Jenner. Now, you guys might have heard about this one a couple of years ago, but to give a little bit of background, Kylie Minogue entered the entertainment industry back in 1979, and her first album was called Kylie, and it made her famous worldwide. She got Grammys, she went platinum in the US, and then in 1996, she actually registered the domain name www.kylie.com, and she used that for various promotional activities, part of her charity endeavors, her charity work in the breast cancer space, was coined the Kylie effect. So it was very clear that Kylie Minogue was known as and established her brand identity simply as Kylie. So Minogue actually did own a range of registered and pending trademarks. So she had Kylie, she had Kylie Minogue Darling, and it was across a range of classes and categories. So we had recordings, we had jewelry, fragrance, obviously entertainment. And then in 2015, Kylie Jenner comes along and applied to register the word Kylie. Now this, of course, coincided with her launch of her cosmetic brand, being Kylie Cosmetics. And that kind of shot her into, I guess, business fame and success. So shortly after her application, Minogue opposed the application, and she did so on 3 grounds. So she said that her marks were filed and used first. Secondly, she said Jenner's marks were confusingly similar in sight and sound, and they conveyed a near identical commercial impression. And Minogue also argued that confusion would be compounded as the marks would be used in similar, I guess, areas and classes with overlapping target audiences. So I guess in the entertainment, could be cosmetics, fame, industry. And Minogue, on this point, argued that the similarity could cause confusion for people familiar with her brand being Kylie. And could be deceived or mistaken as thinking that Kylie Jenner's products are affiliated with hers. And if something were to happen with Jenner's products or services under the mark, this could cause damage to Minogue's reputation. So Minogue argued that she'd spent so much time and significant money building the brand Kylie. And so even if she hadn't had certain trademarks registered, she had established non-registered statutory and common law rights. Now, the third ground she argued, which I kind of found the most interesting and entertaining, was that Jenner's use of the mark would tarnish or weaken the distinctiveness of the Kylie mark. And interestingly, Minogue's lawyer actually referred to some recent controversies involving Jenner to bolster this argument. And I will note there that it's important to note that the concept of dilution is actually not expressively recognised in Australia, but it is in the US. And a further issue was that Jenner's application contained no limitation as to the trade channels it was to be used in. So Minogue reasonably assumed Jenner's mark could be used and accepted across all trade, and that included areas where Minogue might wish to expand to. And in fact, after this, I think near to 2020, Kylie Minogue, did venture into the cosmetic space. I think she was always conscious of that from a business standpoint. Now, I think one possible defense that Jenner could raise, especially in the US, is that there would be no likelihood of confusion. She could argue potentially that her fame and reputation is so established with such a social media following and her brand is so well known that there'd be no chance of confusion. What do you guys think on that? Do you think Kylie Jenner has established herself to an extent where there would be no confusion?
I think Kylie Jenner is Kylie Jenner. I don't know how many people refer to her as Kylie just on her own. I think whenever they refer to the Kardashians or the Jenners, it's usually by their last names. Even though, I think probably in the US more so than Australia.
Yeah, I think that's a fair point.
I would say that her reputation may go further than Kylie Minogue's now, but I don't think there would be an element of confusion there.
Yeah, I agree. I think given those families are so well, I guess, established with their last names, I think you're right. Her fame potentially could succeed Kylie Minogue's in the current social media world. But you're right. I think it's connected to Kylie Jenner as opposed to just Kylie. Setting that aside, so in 2017, Jenner withdrew the application. So there was not a lot of details made public about this. It was very much kept under covers. But Minogue did later refer in an interview that she'd reached an agreement with Jenner. What was funny is that she characterized the legal battle as it had to be done and it was just for business. So I think that's interesting that even, I guess, celebrities with such fame are thinking in this way. while she wasn't successful back in 2017, with her Australian trademarks being withdrawn for Kylie and Kylie Cosmetics, in the US, Jenner has actually since been successful in registering Kylie in the cosmetics class, entertainment, pop culture services. She also has registered Kylie Cosmetics for cosmetic and retail services. And I don't know if you guys have had a look recently at Kylie Jenner's website.
Maybe not Fadi.
Yeah, Fadi, have you had a look?
Not me.
Unless you're looking for concealer.
Yeah. But on the website, I found it interesting. She has, at the top of her website, she has Kylie Cosmetics in two really bold, distinct words with quite a significant space between. And then underneath, she has Kylie Jenner. So I guess her trademark in Australia should be Kylie Cosmetics Kylie Jenner because she's successful in that. But I think when you look at the website, and specifically with reference to the Cantarell and Lavazza case, with Oro being a distinct trademark, even though it's just a word part of greater branding, I think that Kylie could almost be taken as a trademark in its own right because it is so distinct in that bigger trademark of Kylie Cosmetics Kylie Jenner. So I wonder if that's a possible infringement.
Well, opening a can of worms here.
Yeah.
But, I mean, even with the domain name is www.kyliecosmetics and it's on the register, Kylie Cosmetics is followed by Kylie Jenner. Would that be seen as an issue? I mean, like Kylie Minogue hasn't flagged that yet, or hasn't? I don't know. Are we
hinting?
Are we hinting that there should be? No, I'm kidding. We probably shouldn't promote litigation. But when you look at the domain name alongside, which is on the website, pretty close to the title of the webpage, which is, like you said, Kylie Cosmetics in big bold lettering, and underneath, more discreetly, I'd say, Kylie Jenner. Like in the Lavazza case, I probably would say that there's potential for infringement there.
Yeah, I think the domain name, as you said, is really interesting because if I was to type in www.kyliecosmetics, now also knowing that Kylie Minogue has a cosmetic brand, I don't think I'd actually know what would pop up. I'd be interested to see if I just search Kylie Cosmetics, is Kylie Jenner popping up or is Kylie Minogue's cosmetic brand popping up? So it's interesting she hasn't put that Kylie Jenner in the domain name to make it distinct and clear. So yeah, maybe that's a discussion for another time, but potentially there is an infringement there. So yeah, Queen Kylie's had a bit of a battle on that one. And whilst on the topic of pop icons and celebrities, Mariana, tell us about two teenage dreams and one name, the battle between Katy Perry with a Y, Katy Perry with an IE.
Okay, so in, I believe it was 2008, a Sydney-based fashion designer, her name is Katie Jane Taylor, but her birth name was Katy Perry. She went to apply for a trademark as Katy IE Perry. And then following this application, Katy Perry, pop star, let's probably refer to her as Hudson, just for lack of confusion. So we're going to talk about Katy Perry, pop icon, AFL halftime headliner, Katy Perry as Hudson, and we're going to talk about the Sydney-based designer as Taylor, just to avoid any confusion there. So Taylor applied for her mark as Katy Perry, IE. Hudson's team opposed the mark, opposed the application for the mark, and then that was in 2008. Then in 2009, Hudson's team sent a cease and desist letter to Taylor, and following that cease and desist letter, I believe Hudson also offered a coexistence agreement. So Sydney-based designer Taylor could continue trading under her trademark. Well, I'm not sure about what the particulars of this agreement were, but assuming it would come to some sort of agreement that would allow both parties to continue trading under their respective trademarks without any need for litigation, but that was rejected by Taylor. And then we get to 2019, where Taylor commenced infringement proceedings in the federal court against Hudson. And in 2023, she actually had a win in the initial hearing. But Hudson's team appealed that, and the federal court recently in 2024 found that the marks were deceptively similar and ordered for Taylor's mark to be cancelled off the register, which is a pretty brutal blow after a decade almost of litigation.
Yeah.
Also, after thinking you've already won.
Yeah, exactly.
Yeah. So the arguments that they were both making, Hudson was claiming that, you know, she was using her trademark in commerce prior to the registration of Taylor's trademark. There's potential for consumer confusion and that there would be brand dilution. But again, noting that this is not an established concept in Australia. And Taylor claimed that, you know, she's using her birth name. She has a right to use it. She established her business before knowing about the singer and that they're in different consumer markets. So the court interestingly made a little comparison to Big Mac and Big Jack when talking about how consumers were likely to be confused, that the only difference in the Katy Perry mark with an IE and a Katy with a Y was a couple letters.
Yep.
Whereas you had Big Jack and Big Mac being quite phonetically different. And there was obviously the court came out saying that there was a significant difference there. But in this case, the ordinary consumer with an imperfect recollection of, you know, the spelling of Katy Perry's name, Katy Perry being this icon, if they're going to buy something from a Katy Perry branding, they might not know the difference and be confused by that little discrepancy there. So they did conclude that it was likely to confuse and deceive the ordinary consumer. Interestingly, the court talked about the issue of clothing. So just a question before I get into this, like, would you consider headgear and footwear to be clothing or separate?
I think I'd consider them to be clothing, yeah.
So that's funny. I was going to say the opposite because I'm a bit of an online shopper, and I know that when you go online to do shopping, there's often footwear and headwear and are in the accessories category. And then when you click on clothing, it drops down and includes tops, dresses, skirts, pants, whatever. So in my mind, they actually are separate. But I can also understand your argument, Fadi, that it's something you put on, it's something you take off, it would all be included.
Yeah, so Taylor tried to argue, the primary judge actually held that the judges in this case upheld the primary judge's findings that clothing was, you know, by the Oxford definition, something that you were to put on your body, but not headgear or footwear. Taylor agreed with that to a certain extent, but contended that when you tell someone to take their clothes off, you don't leave your headgear and footwear on. So that was her argument. It didn't go up because the court said, without context, we can't really support that. So it was a good shot, I guess, because it makes a little bit of sense. But like you said, like when you go online and when you're shopping, there are different tabs for different things.
Yeah.
If headgear and footwear were in the clothing category, they would be there, but they're not.
I mean,
So
the court also said that if she wanted to raise that issue, she should have done it before, in the sense that she should have made a more scrupulous trademark application.
Yeah.
And that it was beyond the scope of the court to consider it now, because it wasn't even part of her application anyway.
Actually, I was discussing this with Gus, our brilliant IP principal at McCabe's, that specifying what goods or services are going to go with your trademark is absolutely critical and an art almost in itself, because that's what you're asserting your monopoly is over.
Yeah.
And in this case, if you're not clear about what exactly you're going to use your trademark for, the court are not going to go with any ambiguity. They're going to go with what exactly you put on the register. And they upheld the primary judge's findings on that.
Well, I think, Mariana, that is a really interesting point, and it kind of leads us into the takeaways from today's episode. Fadi, one thing that was kind of brought up in your case is having a strategy in place for your brand.
Yeah, exactly. So Hungry Jack's was very, very careful and very, very deliberate in their defense. Didn't want to defend their trademark on the grounds that it was non-distinct because, or make the argument that the Big Mac and Mega Mac trademarks were non-distinct because it would, in effect, also take away from their trademarks. So, and I think the key takeaway with that is if you're litigating trademarks, make sure to have a strategy in place and know what you're defending so that it doesn't hurt your own case.
Yeah, definitely. I think not even just litigation in general, have a strategy in place for your IP and your trademark protection. And I think that's important to know that needs to be on a global level with trademarks as well. And a part of that strategy, Mariana, is there are other options. You don't have to go into these big battles. It's one thing we saw with Katy Perry.
Yeah, not biting off more than you can chew. Even though, you know, in Australia we love siding with the Aussie battler. And usually I don't tend to sway towards like a mega rich superstar, but in this case, the offer on the table was a coexistence agreement. The court said too late, can't go back to that anymore. So had that really been thought about, strategized, had there been someone making an assessment on the risk appetite for this trademark and, you know, doing your due diligence even before you apply for these things, there might have been a lot of costs that would have been saved. Definitely time,
heartbreak,
stress. And yeah, now she can't trade under the name that she said was a dream of hers since she was 11. So
yeah, and that's hard. And I think kind of bringing it all together, I think you have to be smart in the strategy you take with your business. Small businesses should remember that being able to leverage cheeky taunts, kind of what we saw in Hungry Jack's, Macca's, although they're not a small business. But adopting that for sales and publicity might not always be the best route to take. As we saw in all cases, litigation's costly, and unless you have pockets as deep as a fast food giant, do your IP due diligence, consider what risks, and think about your approach.
Yeah.
Yep.
Well, great discussing the trademarks with you guys.
Thanks, guys.
Thank you.